You are sending them an email, no, Fabio? Otherwise, I can do it. Yeah. Okay. Otherwise, it will be a fully. I hope Diana and Susana are ready to speak for the entire panel.
Yeah.
Sure,
We're going to delete
speak.
Chile from the purely
We can
Colombian.
even talk about Chile.
There you go.
Do you think that maybe they mixed up the time?
The time, yeah, most probably. No.
Both of them, because
Yeah, because it's two coincidence. No, both of them did not join, right? If it was just one, because we had 8 Eastern time. I don't know in Chile what would be the time right now, but
I think, Fabio, in the worst case, if in a couple of minutes they don't join, I can start and we give them time, no? That could be one option. And yeah, I don't know. It's up to you. I am willing to do whatever way you prefer.
No, yeah, I don't want to delay more, because at the end of the day, or they are mistaken about the time, right? Because both are late. It's strange that both are late. They may have, or they are having difficulties in joining. I'm waiting. You accepting me, Rafael.
Sim.
A gente tem os panelistas, alguns estão esperando para serem aceitos. É você que aceita?
Nesse caso, eles entrariam como
panelistas no
então,
painel.
Se eles estão
Speakers.
esperando, é porque provavelmente eles estão entrando como participantes. Assim, a gente tem duas opções. Esperar começar e eu puxo eles para panelistas, ou eu já inscrevo eles aqui agora, se você tiver o e-mail deles.
Você
eles
consegue?
Começam agora?
Não, eles não começam falando. Você pode puxá-los?
Posso.
Você consegue?
Então acho que essa é a melhor opção, mais fácil.
O problema é se eles realmente não... Eu posso mandar o meu link para ele?
Você até pode, mas eles vão entrar com o seu nome.
Ah, tá bom. Então não. R, você anota aí um dos e-mails que já está esperando. Reveco, @ Eu vou colocar aqui no chat, tá?
Melhor,
vou colocar no chat os 2 e-mails, tá bom? Vamos começando. Aí eu abro pro primeiro, já o Andrés que vai começar a falar.
Tá, então eu posso abrir agora.
Mas escuta, você vai chamá-lo, você vai chamar, né? O Ricardo, você tá vendo aí no chat? Certo?
Vou abrir aqui.
O Ricardo e o Hugo.
Tá.
E o Hugo aqui também, ele falou que ele clicou.
Tá bom.
Peraí, eu vou mandar o e-mail dele também. Você puxa eles e coloca aqui?
Puxo sim.
Tá bom.
Só que eu tenho que iniciar para isso.
Isso, não, eu entendi. Vê se você... Ué, por que não tá indo aqui? Tá aqui, ó. Você viu os 2 e-mails aí? Isso. Tá, qualquer coisa você manda e-mail para eles e fala direto com eles?
Sim, pode deixar.
Eles estão esperando há 15 minutos. Obrigado.
Então
vamos...
posso iniciar?
Pode.
Todo mundo preparado, então. A partir do momento que eu iniciar, as pessoas vão entrando e todo mundo vai ouvir vocês. Vou iniciar então agora.
Well, good morning. Good morning, all. We are initiating, good morning. We are initiating our event today, a World Bank and International Insolvency Institute event to discuss the main principles on World Bank and the small and micro business regulation on insolvency in our countries through the region in Latin America. This morning, we have Chile and Colombia as the main as the systems and the experience to explore, and we have a panel of stars, I would say, to debate and to discuss applies on the principles of the World Bank on insolvencies to SMEs, and we have a very special also speech from our keynote speaker, Sanchez. Andres Martinez, sorry, Hugo Sanchez is joining us. Andres Martinez, let's start with Andres. We're gonna have our panelists from Chile joining soon. Hugo Sanchez, who is the superintendente on Superintendencia de Insolvência e Repreendimento in Chile, and Ricardo Reveco from Carey law firm in Chile. And we have from Colombia, Diana Rivera Andrade, lawyer from Rivera Andrade Studio Jurídico de Bogotá, e Judge Susana Hidvegi, hope I speak correctly, Arango, superintendente, delegado superintendente de sociedades em Bogotá. Our colleagues from Chile is joining us soon, but we're going to start this morning with our explanation about the World Bank principles with Andres Federico Martinez. Andres is a senior financial sector specialist with the World Bank. Andres has been a lawyer for over 20 years, has a master's degree in corporate law, and specializes in insolvency and creditors' rights. For over a decade, Andres has been advising countries from Latin America, Middle East, Europe, and Asia on legal reforms with focus on debt recovery, insolvency laws, and workout mechanisms. Before joining the World Bank in 2008, Andres worked in private practice, representing large creditors in litigation and insolvency cases. Andres is an Insol Fellow, co-chairs the World Bank Insolvency Task Force, and chairs the World Bank and Insol International Legislative and Regulatory Colloquium. And we will be very glad of having Andres speaking about the World Bank principles, and I incentivize our audience and the people who joined our audience to send their questions according as far as our debates develop here. We have the Q&A link for the audience to send questions, and we'll try to respond and answer all the questions at the end of our debates, right? So let's start with Andres. Andres, who I met more than 10 years ago. He was a young practitioner, and he still looks like a young practitioner, although a very long resume and bio and very long experience in insolvency and pretty much active. We first met in a triple Y event more than 10 years ago, certainly in New York, and hopefully our members from triple Y will have the opportunity to hear the experience and the deep work that Andres and the World Bank did on our area. Thank you, Andres.
My pleasure, Fabio. Thank you so much for the very, very nice introduction. It's true that we met more than 10 years ago, which is it's been quite a while. But it's always a pleasure to partner with the AAA. At the World Bank, we've been doing quite a bit of work in this area, and we are conscious that the AAA always focuses on large cases, but this is obviously a topic that is very relevant. Very relevant too, the small and micro enterprises, which sometimes goes unnoticed, but as we'll see, the small and micro enterprises are absolutely fundamental for the economy. And at the World Bank, we at least have 3 very strong reasons to be working in this area, in the space of micro and small enterprise insolvency. Obviously, the first one is importance for the global development. This is they represent. Obviously, each country has different numbers, right? Sometimes it can be 70, sometimes it can be 80, 90, but globally, they are about 90% of the businesses, right? We can say that with the relatively limited information that they have, because oftentimes they are informal, oftentimes it's sole entrepreneurship, so it's never so easy to get the most accurate data on micro and small enterprises in particular, but their relevance for global economy is undeniable, and I think everybody here can agree on that. What is also particularly relevant for our work at the World Bank is the fact that in emerging markets, most formal jobs are generated by micro, small, and medium enterprises. So you'll see a lot of MSME in the slides. That stands for micro, small, and medium enterprises, if I clarify. But basically, they create 7 out of 10 jobs in emerging economies. This is something that is absolutely critical from the perspective of poverty reduction, from the perspective of employment, of generating employment, and as we always say, also keeping employment when it comes to the restructuring and the possibility of saving these enterprises. So the second reason is that the COVID-19 crisis, and not only the crisis itself from the economy and the health perspective, but also the lockdowns that generated, has disproportionately affected the low-income economies and smaller firms. And this is for several reasons. The first one is that they dominate the sectors that have been affected the most, including small hotels, like the boutique hotels, small transportation companies, and so on. We are talking about a lot of small restaurants, of course, and a lot of small industries that have been really badly affected by the lockdowns and, of course, by the COVID pandemic. In parallel with this, as you very well know, the possibility of these companies, the smaller the company is, the more difficult to have access to credit is for these companies too. Not to mention during insolvency, of course, but basically the possibility of these companies to avoid insolvency by getting some extra sources of credit is much more complicated, unless, of course, they come from the state, you know, as many governments do. So, and finally, the big question is that has been going around, floating since this the COVID pandemic started, is will there be a wave of bankruptcies or not? And this is particularly important when we look at the insolvency systems in general, and we look at whether they are suitable or not for very small and micro companies. As you can see, I've been avoiding the very difficult topic of what is a micro company, what is a small company, right? And here, of course, we defer to each country, and because whatever is a small company in China will most certainly not be a small company anywhere else, will be a large company probably, right? In many other countries. So here I will obviously, whenever I say micro, whenever I say small, please think in terms of your own legislation that typically has definitions of what a small or medium companies are, right? The question of whether there will be or not a wave of bankruptcies has been generally responded as beginning with fear. What will we do? the world is is coming to an end. And then of course there are three things happen. First, governments started pouring money, all the fiscal stimulus going to the economy, where a lot of individuals and companies of all sizes received some sort of benefits out of these programs that can be of many different sorts, right? Either grants or credit, etc. Second, many countries enacted some sort of moratorium that prevented creditors from exercising their rights, sometimes for a very small period of time, as I'm sure that we will hear today, and sometimes for a longer period of time. And finally, banks and other creditors are scared because if they start enforcing to all the debtors, they know that their NPL portfolios will skyrocket. So it's better to negotiate and try not to put all the portfolio of NPLs, of non-performing loans, of loans that what we call tasa de morosidad in Spanish, that may be due for 90 days, for example, or more. They are being very cautious still, but this may happen. This may change. This will have to change at some point, and this will, of course, generate, I don't know if a wave of bankruptcies. Many creditors will just go for individual collection processes, which can be enforcements of whatever, if there is a collateral of collateral and so on. But that the increase of debt has happened is undeniable, and that debt will need to find a point of resolution. Now, when it comes to insolvency of micro and small enterprises, we face some challenges, either in this crisis or in normal times. And these specific challenges are, first of all, the informality. The informality of the micro and small companies is notorious, right? And they may lack balance sheets, for example, and they may lack a lot of information that insolvency laws typically require to be able to start an insolvency process. They face an issue of creditor passivity. Many creditors just don't participate or don't vote. As you know, many insolvency laws, if creditor doesn't vote, then a liquidation starts because the proposal has not been approved. Access to financing during insolvency is a dream. Right? They struggle to access finance even without an insolvency process. Within an insolvency process for micro and small companies, this becomes extremely complicated, much more than for large companies. Sometimes there is the issue of no asset cases, which obviously affects more the micro and small companies than large companies. In the discussion at the World Bank, we decided to take the medium out. That's why you see MSE. We focus mostly on micro and small enterprises because the medium enterprises have been using the system, the insolvency system, quite a bit. So the principles, of course, are optional for medium-sized companies, but for the others, we are considering them as features that are part of good practice, right? And if a law does not, an insolvency system does not contemplate certain features for micro and small enterprises or small cases, then we would consider it not meeting international standards. And as some of you may know, the World Bank is a standard setter in insolvency together with UNCITRAL, designated by the Financial Stability Board. So whenever we do what we call financial sector assessments, we always look into these things, right? Of course, there is always some tension between simplified regimes or micro enterprises. We always consider it the same. It doesn't really matter if it's for very small cases or for micro enterprises. I think it could be considered as a synonym as long as there is a specific chapter within the insolvency legislation or a specific law, as it happens, for example, in Korea or in some other countries, that deals specifically with micro and small enterprises. So we'll see a little bit what the World Bank has been doing in this area. We started working on this in 2017, where we worked on a report on the treatment of micro, small, and medium insolvency at that time. Well, I had the opportunity to lead that report, and mostly I have to say that that report came with a lot of comments about the medium size being excluded, and of course it based a lot on the modular approach book that was being written at that time by some of our AAA friends. So that was a shout out to that to this group of academics that also explore this topic quite in depth. A year later, we published another report. All this is publicly available. I'm more than happy to share the links, called Saving Entrepreneurs and Saving Enterprises. And that was on purpose because one of the main challenges that we had was the intersection between individual insolvency and corporate insolvency. So all the entrepreneurs that are natural persons sometimes use their personal credit card to buy something for the company and so on. The intermingling of assets can be quite complicated to make a clear distinction between the natural person and the company in the cases of micro enterprises in particular. So we put forward some proposals. We discussed them in 2009 and 20 with the World Bank Task Force, and then we finalized the principles this year in April. And we'll see now in the next slide, and I believe the last one, what we the proposals that were finally approved by the World Bank Task Force, and this is nothing surprising, convenient, inexpensive, easily accessible. We discuss a lot about technology, how to facilitate micro and small entrepreneurs access these proceedings, minimizing procedural formalities, and here particularly the barriers of access are considerable in most legislations. The requirements that are asked to micro entrepreneurs can be quite complicated and daunting. But of course, if you get it wrong, you have to convert it to an ordinary proceeding in an easy way. If you realize that this company is not micro small, but a large company, or it's in the gray area where it would benefit from a complex proceeding, then there should be a conversion. Then we discuss a lot about how to address the issue of creditor passivity. When we said creditor passivity, remember it's banks just unwilling to deal with such a small case, simply because it takes them time that they dedicate to large cases, of course. And the reality is that our conclusion is that no vote is an implicit yes. Of course, a negative vote should be considered no, right, to the plan. And here it's complicated because UNCITRAL went a little bit further and suggests to have to give creditors the right of opposition to the plan instead of a negative vote. Basically, it would be like a negative vote, but has to be justified, which we thought it was going too far. But that's kind of there. It's still in discussions. UNCITRAL has not finalized their work, but it's something that as you can see, dealing with the issue of the lack of participation of certain creditors, particularly the large ones, can be complicated. Obviously, management of business by the debtor should be continuing. The issue of insolvency practitioner, do we need a syndico? Do we really need it? Maybe we can save some costs there. There is, of course, something to think about. The same with the discharge of good faith natural person entrepreneur. This is something that, for those of you familiar with the European directive from 2019, you've heard a lot about this, right? So entrepreneurs cannot be bound with their debts forever and ever, because otherwise that person stops contributing to the economy. So there needs to be a point of discharge to that entrepreneur, so that person continues to contribute to the economy. And of course, if it's 3 years after the process, if it's 5 years, if it's 1 year, each country decides. The European Union decided no more than 3 years, and all European countries are now adjusting their laws to meet that that requirement. And finally, of course, institutional considerations, and this is something that will resonate quite a bit to all of you. I mean, and it's our judges, and I'm not saying this because our co-panelist Susana is a judge, but I'm saying this because it's a reality. I mean, our judges in all Latin American countries are completely swamped and under-resourced. We can, discuss about, the quality of decisions, the length of the process, but to the extent we have judges that are that have more cases and not sufficient resources, then then we can't expect an administration of justice that is super fast and efficient, because we're asking for something that is very difficult to obtain. So the question is, do we need for micro companies, do we need for individual entrepreneurs to involve one of the commercial judges that are dedicating their time to really large cases? Or can we move this to smaller venues, perhaps? And I think that's one of the questions that is posed around. And of course, this is something very institutional and very personal for each country, I say, but it's something that we invite countries to consider, right? Whether there can be some sort of mediation in insolvency, which is a hot topic nowadays, whether there can be some chambers of commerce dealing with micro entrepreneurs, perhaps, or debt advisory centers or something, right? That could be obviously freeing up the judges for those cases that really matter for the economy, the large cases. And I'm not minimizing the importance of the micro cases, please don't get me wrong. I'm just saying that perhaps they are dealt with more efficiently by courts that are a bit smaller. So with that, I think I posed quite a few questions and a few thoughts, and I am really looking forward to Fabio's panel and to all these absolutely excellent panelists. I know Colombia has done something tremendous during the pandemic, something fantastic. I know Chile has been also trying to achieve a legal reform, and I think both countries are incredibly advanced and sophisticated. So I'm really looking forward to hearing from them. Thank you so much, and I will stay for the Q&A, of course.
Thank you, Andres. A wonderful presentation, and certainly we count on your view and your experience in our debates here. And it's impressive how the principles and how the report right from World Bank and the principles are pretty much accurate, I may say, from Brazil, because the main, let's say, problems or the problematic is pretty much well exposed, and the proposals and the suggested solution seems to be very relevant, at least for a good part of our economies, right? In developing countries, emerging markets, and Latin America. Through Latin America, we have a very sensitive part of the employment and even the economy, although not formal, as Andres says, should be addressed when they find, or when they pass through a crisis or a problem with a financial problem, or even a market or a more systemic problem, as we had during pandemics, which was even more sensitive in small business, micro businesses, small service providers, and restaurants, as Andres says, etc. It's a very important part of the nations, and the population suffers a lot when this happens. So let's go ahead and hear first of all, sorry for the inconvenience, and Ricardo, it was not Hugo's and Ricardo's fault. It was a technical problem that they could not join on time, but we could fish them to join our panel today. But let's start with the give privilege for the woman on the panel, and start with Susana from Colombia. And Susana has, I believe, information, data, and statistics as well. We're gonna hear from Chile, but let's start with Susana and Judge Susana, and then we go also to hear the same, let's say, numbers and data from Hugo from Chile, and then we start debating about the statistics and the actual, let's say, actual problems and real life problems as well. And we're gonna switch to Spanish, right, Susana? And then we may, I ask the panel to continue in English if it is possible, because my Portuguese is really bad. Sorry for that. Susana, please.
Thank you very much, Fabio. Thank you to the World Bank and to the International Insolvency Institute for putting this magnificent event. I also want to thank my co-panelists, Hugo Sanchez and Ricardo Reveco from Chile, and Diana Rivera from Colombia. And thank you, Fabio, for being the moderator of this panel, I would like to confirm that you're seeing my screen, my presentation, right?
We do, yeah.
Thank you very much. So, well, Colombia, as many or probably every country, began to develop some plans to face the effects of the pandemic. So from the perspective of the Superintendence of Companies, which is an administrative entity with judicial powers as bankruptcy court, we also started to see that the small businesses could be the more affected with the measures and the pandemic, as Andres was saying, the close downs of the economy and all the lockdowns and all the restrictions will probably affect more in the immediate time to the small businesses. So we actually have 70% of the insolvencies are related to small businesses or sole enterprises, and that was a real concern for the government of Colombia. So we had the chance to create a specific bankruptcy law for small enterprises. As Andres said, it is hard to say what is a small business for each country. So our trigger or our limit is about $1.2 million in property and cash and everything. So that's the trigger to consider that business is small. That's the maximum amount of assets that the company or the business, if it's a individual person, could have to access to this proceeding. So we develop, and I'm going to show the flow of these proceedings. We developed simplified proceedings for reorganization and liquidation in a response to have proceeding that is appropriate for this type of businesses. So these proceedings incorporated both legislative guidelines for the creation of simplified proceedings is issued by UNCITRAL. This was before the approval of these guidelines, but the discussion has been gone for some years now, as well as the World Bank principles. Of course, the updated version was issued later, but I believe that our system includes the main principles, and I'm going to refer to that soon. So with regards to the UNCITRAL guidelines, Group 5 of UNCITRAL held that such debtors may be discouraged by formal insolvency proceedings because they are lengthy, they are sometimes rigid, and they don't offer the flexibility required by these small businesses. And from these recommendations, our simplified proceedings include probably that it is easy to access. These proceedings must be filed through a system that incorporates some tech tools such as artificial intelligence. So these are some pre-established forms that make it very easy for the entities that must file documents to know exactly what the court is expecting. So this has been effective in the sense that these small businesses sometimes do not have lawyers or experts in the advice for the proceedings. So it's very helpful that they have a system that will somehow guide them through the process of the filing. Also, the process has the possibility to coordinate proceedings between the small enterprise and the owners. because it's a very common problem that the owner, the person behind the business, will end up mixing up the assets or being a guarantor of the debt of the company. And also, as Andres mentioned, this represents a great workload for courts. So what we did is actually follow this principle of having a separate court for the small proceedings or the small business proceedings. So we have special judges in the insolvency court at the superintendents of companies to administer or manage the reorganization for small businesses, and another judge to manage the simplified liquidation for the small businesses. And also we have developed with the legal framework a way where the clerks help the judge to prepare the hearings by carrying out conciliation or settlement hearings with the parties, somehow encouraging them to reach agreements that will be ultimately reviewed and confirmed by the court. So with regards to these principles set by the World Bank, it is an inexpensive and convenient and accessible proceeding, in the sense that it is free to file. It is not necessary to have a lawyer or attorney or advisor for the proceeding. The system will guide the user how to make the filing. Also, the formalities have been lowered to the point that for the admission or the commencement of the proceeding, the court will only check that the documents are complete, because that's necessary to go through this proceeding. We could not implement the approval or the implicit vote. This was stricken from the project, although it was included in the first versions, because in Colombia there is a long tradition of voting, but we included something similar in the sense that the objections that are not duly defended during the hearings will be deemed to be waived. In that sense, we are trying to face as well the inactive creditors that are not being there for the relevant stages of the proceedings. Also, the debtor keeps the management of the company during reorganization. This does not happen during liquidation. During liquidation, a court officer will be appointed, a liquidator, or in Spanish, liquidador, for all the tasks to be done during the liquidation. We have a discharge for natural or individuals in the special proceeding for not merchants that is done before the arbitration centers, but during reorganization proceedings, it is possible as well to go through and agree upon discharge during or within the reorganization plan. And that's the way we believe we have implemented these principles in Colombia. This is included in Decree 772, which is a presidential decree issued within the emergency. So we are expecting to have these implemented for as a permanent legislation, or at least extend the application for some time. So I'm going to show briefly how this proceeding works. This is the reorganization, the summary reorganization. This proceeding takes around 5 or 6 months in comparison with an ordinary reorganization that will take about 20 to 24 months. So this is the commencement with the filing, then the court admits the proceeding, then there is a meeting where the parties will try to reach an agreement. It is not a hearing, it is a meeting. So that's why the clerks are able to help or encourage the parties to try to settle their disagreements, and then there is just one hearing where the judge will resolve the objections that were not settled and then confirm the agreement. So these are very outstanding statistics, I would say, because implementing these alternative resolution mechanisms during the proceeding has been very successful. We have a success of 85% of settlement of the objections during this hearing. These settlements are then reviewed by the judge. But during 2021, the settlements have reached 90% over the objections. This means that the parties are understanding that the purpose of the proceeding is to reach a solution that is useful or the best possible for everyone. So at the end, for the judge, the proceeding gets easier to handle because the hearing will limit to the 10% of the objections that were not settled, and then the review of the agreement. The judicial liquidation, this is the simplified. It doesn't look very, very simple, but in the end, it takes less time. It's about 7 months in comparison with 2 or 3 years of an ordinary liquidation. And these are some statistics also to show how these mechanisms created by the emergency have been actually used a lot. So since the beginning of the pandemic, we count that from April 2020, we have the commencement of proceedings created under these new laws. 76.33% are small business proceedings. These are divided between reorganizations and liquidation. So this is actually very, very important for the Colombian economy. And as we can see there, this is probably a lot of small proceedings that represent a lot of work, but also a lot of impact in the economy. So that's the information I wanted to share with you, and thank you very much.
Thanks, Susana. I was about to say that judges in Latin America are much better because they should have present more work, or they do more a very strong task and more job with less resources, right, as Andrade says. So so they are much better than the rest of the world. So but very interesting, yeah. And the challenge and in fact the problems and the challenges, especially regarding costs and trying to expedite the proceeding and simplify the proceeding is really a challenge. And it seems impressive, the numbers, right? Because I was impressed that the numbers worked so well, at least for a simplified proceeding. And liquidations in Brazil, if in Colombia you have 2-3 years, we have some here lasts forever, you know. So we never see an end in a liquidation, unfortunately, sometimes. So let's go to Chile and understand the scenario and the data from Hugo and the statistics and the numbers as well, in order for us to have a more, let's say, a complete and different experience to talk about. Hugo, I believe Hugo has a presentation as well. Thanks, Hugo, for the participation.
Yeah, hello, Fabio. We talked with Ricardo, and we think that we changed turns
okay.
to have Ricardo start with his presentation,
Okay.
because he is going to mention some challenges that we are, you know, through our law amendment, we are making some changes to afford these challenges that Ricardo is going to present.
Sure, that's why you were late. You were combining in the backstage. So yes. Okay, no, I'm kidding. Ricardo, please.
Thank you so much. Thank you to the World Bank and Fabio and our friends for this invitation. I would like to share with you this presentation that we have prepared for this meeting. I don't know if you can see it.
Yes, we do. Thanks.
Okay, thank you so much. Well, we know that, and Andres explained, and also Susana, that this kind of entities, the SME, are facing a lot of problems during this time because of the pandemic. But also in Chile, we have, as you may know, a social crisis that may face now amendment to our constitution, or a new constitution. And it has faced or created a lot of problems to these entities in Chile, which, as you may know, are very important for our economy. But I think that they are very weak. They have a lot of this kind of entities had a lot of problems to participate in the economy. Something of this was explained by Andres, but only want to mention from the financial point of view that these entities has limited working capital. They usually pay higher interest rate. It's difficult for them to go to the banks. They usually go to factorings or that kind of ways to finance their operations, which are very expensive for them. And also in this kind of entities, all the family and the owner had granted collateral, avales, fianzas, codeudas solidarias to can participate in the economy and to obtain some loans. And this create a lot of problems to these entities, and this create also the high probability that these entities fail in the payments. So which are the problems that after 5 years of this law, we have from 2014 and a new insolvency and reorganization law that creates proceedings, and I think it was a revolution for us. And I think that Hugo will explain the statistics, but we have now a lot of proceedings in our country, thanks to this law that I think that help us to be in a better way in comparison with other countries. But after 5 years of this law in force, I think that there are some common conclusions of the application of the law that we need to address in order to eventual changes to the law. I am a practitioner, so I have suffered with these problems when I am dealing in insolvency proceedings. So I'm talking from my experience. But I think that the big problem that the law has is that the model of the entity that will enter in a proceeding is a unique one. We rely on a tax concept in the law, defining which entities can file some kind of proceeding and which are the individuals of the consumer liquidations. But this has created a real problem for the entities that we are talking about, for the SME entities. So our model is thought by the assumption that these proceedings are for large entities. So with this big problem, I think that I can identify 3 kinds of particular problems or detailed problems in our insolvency legislation. The first one is procedural. We have problems with the proceedings. We will explain, and Hugo will explain what he is leading in our Congress to reform the law. There are also problems from the point of view of the cost and benefits incentive for filings. We also have a problem there. And I think that we have also a systemic problem that is, I think, more in our culture. We are just, with this new law, having a new insolvency culture, but we need time to really have an insolvency culture to help entities to to have a fresh start. So I will explain now which are, from my point of view, the procedural problems that we have. As I explained before, we have not a defective definition from which entities can enter to a reorganization plan, renegotiation plan, and liquidation plan. And this has created a lot of problems. For example, a natural person, an individual, who issue a boleta honorario, which is an invoice, has problems for filing a reorganization or renegotiation. So the law has to be amended to clarify and to help individuals and entities, as we are talking about MSME, to define which is the proper proceeding for them. So we have here a defective definition of debtor. The second one, which is something that Andrade explained before, is that we have high problems in the proceedings because we have a lot of hearings, we have high quorums. So at the end, this creates in the liquidation proceedings or in the reorganization proceedings a big problem for the approval of the reorganization plans or for some decisions that has to be made in the liquidations. So I think that a solution for this should be, I think, to facilitate the participation of the creditors, is to reduce the hearings, to allow the virtual hearings, or as Andres explained, that assumption that a positive vote in some cases. But we have a problem with the hearings because at the end, with this kind of hearings and the way they are being held in the courts and the quorums that they require, at the end, they create the lack of interest of creditors to participate in this proceeding. So we need to resolve this in the amendment. The third problem from the procedural, the proceeding, is the role of the judge. The judge in Chile is a spectator. He doesn't participate in the debates, in the negotiations. He doesn't have the power to clamp down. He doesn't have the right to review, for example, the terms of the debt financing. He cannot impose the plan to the creditors. So I think that this is a problem that we have, and we have to think how to solve. And same situation, thinking in the reorganization of these entities, of the micro, small entities, is the role of the supervisor. We need to think that this guy, as Susana explained, they have people help creditors and debtors to have a settlement or have an agreement, and we have to create more supervisors to help creditors and debtors to agree on a plan. And the fourth problem that I identify here is that we need to reinforce the simplified proceeding. This is a very important tool, but we have a defective regulation, which, for example, we have a limited stay. We have problems from the challenges or the appeals. For example, if one of the creditors appeal the organization, the plan or the simplified plan, this plan cannot be enforced and applied. So we give a lot of power to one creditor to suspend the effects of a simplified proceeding. So I think that making little changes in the law, we can reinforce this proceeding for these small and medium entities when they want to file for a reorganization plan. From the cost and incentives, also this was said by Andres and Susana, these are barriers very important for these little entities. You have to pay the supervisor fees. You have to, for filing You need to file the certified audit by a public auditor from our SEC agency, which is expensive. You also have to pay the fees of your attorney because this has to be filed by attorneys. This is different from what is happening in Colombia. So we have here a problem with a cost for entering this proceeding. We also have, and I put in red, a very big problem because it's difficult when companies entering this kind of proceeding to obtain financing. Because the banks has special provisions from when one entity enters in reorganization. So I think this is a very easy way to solve the financing problem is if our bank agency change the rule of provisions. Because the problem is that if I enter in a reorganization plan, and if I want to finance my operations, I will not be able to go to the banks, and I will have to go to the secondary market, which is expensive. My experience is that we are here in Chile paying 2% per month for financing in this secondary market, which is very expensive. So with a little modification of our bank regulation, we will be able to give some fresh air to these entities to obtain financing not so expensive. And I will follow with the next one. And the last point is the systemic. I think that we have, as I explained, this law was a revolution, but we need to change our culture. Up to now, I think with the experience, it's a problem to be in an insolvency proceeding. And this creates problems in the financial and the commercial system. So we need to change. We are doing this, but this needs time to create a new culture in the insolvency because the problem is with as this is a stigma, at the end, companies avoid filing. This aggravates the situation of insolvency and creates, or a company enters with a delay that doesn't help creditors and the entity to be able to have a fresh start. That's my presentation, Fabio, and thank you so much.
Thanks, Ricardo. And hearing from you, it seems that our country here, Brazil, which was the subject on the latest panel, is pretty much, it's more Chilean than Colombian in terms of those let's say those difficulties, right, and the costs involved and the necessity and the need of the lawyers, and which I believe the fees are completely fair to be paid, but anyway, we should have for a simpler business, we should have simpler and less complex and less costly proceedings and mechanisms that they may use. And I have questions to make for you after. And let's hear, before continuing with Chile, let's hear Diana, because Diana has, also as a practitioner, a lawyer, has experience on actual problems with the insolvencies and the small business environment as well, and see what happens in Colombia. And then we may switch to Hugo after that, and hear Hugo and Andres, and let's see at the end if we have more solutions than problems, right, Diana? But let's identify the problems as well.
Yes, thank you. One second.
Do you have a presentation as well?
First,
yeah.
I want to thank to III and World Bank for the invitation to this webinar, and I hope that all the participants are healthy and we are right because the pandemic is still here. And I am very glad because I can share with my colleagues in this panel. I think that all that they said applied in Colombia also, and in the reality of SME. So before of this meeting, we decided with Fabio that we'll show you the problems of SMI and SME, new proceedings introducing during the first month of the COVID. Like Susana tells us, because of the COVID, the government decided twice declare a state of emergency. And the first time was on April 17, and during that time, they established 4 decrees related to insolvency. Before I explain shortly some aspects on numbers about our economy, I have to tell you that the Superintendency of Corporation is our natural insolvency judge. And before the pandemic, the Superintendency was working on a project to reform our principal system that is contained in the Law 1116. So first, I want to explain what is a small company for the Colombian law, because Susana explained about what is a small company for insolvency law. But for our normal law, a company is any economic exploitation conducted by a person or legal entity. And the size of the companies are micro, small, medium, and large companies. And you can find different criteria for classification, but our law, normal law or general law, set this classification based in the total of annual income from ordinary activities. And a small company in Colombia has annual income up to $300,000 revenue. That is the size of a small company. Micro company, and a small company is up to US dollars 2.4 million of dollars. So we don't have a big company like the SBRAS in the United States with 7.5 millions of debts. No, we are smaller. So we found here our first issue. While the general law classified based in annual income, the new insolvency law classified based in the value of the assets. And the value of the assets are or will be $1.2 million of dollars, the assets. And so the door for the small proceedings will be open. Second issue, I want to explain the business sector, but I think that Andres told us about the importance of the small companies in the global economy that represent 90% of this, the base of the economy is the same in Colombia. We have around between a micro and a small company, we have 97% of the market. 97% is so big. So if we have to preserve our economy or face the crisis because the pandemic, we have to find the way to help these entities. In the other hand, only one date or some information, during the 3 first months of 2021, here in Colombia were created daily 93 micro business, 93 in the first 3 months of 2021. So we have a big problem, and also we have to say that the 70% of these companies, of these new companies, or the companies that are created during the year, has sold property, are not true companies or corporation are person who create a business and go to the street to look clients and found resources and all these things. What is the meaning of that? That the micro and small companies are the base of our economy. If you say or you look the numbers of the superintendency in the Atlas of Insolvency that is published or hung in the website of the superintendency, you can say the numbers. You can see the numbers of how many companies, how many employees, how many represent the assets of these companies. About our insolvency system, we changed a lot in the last 30 years. We had 5 different laws, almost very proceedings, very judicial, not so flexible. So about this decree 7072 of 2020 that said abbreviated reorganization and simplified liquidation for debtors of Article 2 of Act 1116 with assets are less than or equal to 1 million. I want to say that my reflections are about small, micro, and small companies, because these proceedings maybe are useful for big or medium companies, but for small and micro companies, I don't think so. So what is the motivation for this new proceeding? I have to say we are very proud from our superintendency, more from the group of the judge of Susana, not because she's here, I tell her before that, but they work a lot all this COVID period, but we have the problems remain there, some big problems that we have. So what is the motivation, or what were the motivation of this new proceeding? First, face the crisis. Yes, you know, when you face a crisis as our government, you have to change rules, the insolvency rules, and look some ways more flexible to handle this crisis. Because if you judicialize every single crisis, it's more longer, more cost, more expensive, more complex, everything. So that is the first. Second, the UNCITRAL recommendation. We know the simplified insolvency regime that was set this year in June or July in UNCITRAL, and is a document that Group 5 has been working a lot of time. So the superintendency and the government consider this recommendation. Third, a catastrophic prediction for insolvency cases. Yes, when you read the emergency rule, you can see that the government predicted a tsunami of insolvency cases with a number around 7,000 or 5,000 proceedings. And really, we have something like 1,500 new proceedings, something like that. So that the prediction, thank God, was not materialized or concretized. But if you compare June 2020 and June 2021 in this Atlas of Insolvency, the admissions are less in 2021. So it was not so catastrophic again, thanks God. For court congestion and delays. How I said before, the Superintendency of Corporation is our natural insolvency judge. It's specialized because we don't have commercial jurisdiction. We have only civil jurisdiction. So if you want to discuss about a franchise contract, you have to go to civil court, not to a commercial court. So we have a big problem. Thank God, again, we have a specialized court, but we have a problem because this superintendency have office only in 7 big or medium cities. We have a geographic barrier to go to the judge. Second, the superintendency didn't and doesn't have enough resources, people and budget. So we have a lot of problems, but we don't have resources. And speaking about the World Bank principles, we are we have problems with the principle D about institutional and regulatory frameworks, especially because our court is inside an administrative entity, how explained Susana. That means that the court, very sad, is subject of political influence. Right now we have a problem because the superintendent, the head of the superintendent, the entity, was required to resign because political problems. So even the insolvency group worked very hard. We have these kind of problems. An example of that is the judge is free appointment and removal. I can believe that we have a judge that you can remove only because the president changed, for example. And we committed with the OCD that we are not do that anymore. But that happened, that I tell you, that happened 2 months ago. So we are facing this crisis in the insolvency court, and we are asking to the government to don't go away the work of the group of insolvency that exists right now. We need, I always say that, we need a career judge, instead a judge appointed, a removal with unwanted consequences like the continued changes in the president with the subsequent judicial insecurity. Always say who will come in here in the superintendency. And 5, online and virtual justice. The use of artificial intelligence, even though we have been filing and looking at procedures online before the pandemic for the last 5 years at least. From September 2020, we can file insolvency proceedings, filing some forms with some documents attached, and the artificial intelligence. Apply the rules and set admissions. This also related with the solution of the congestion and delays of the court, because before COVID, if you file an insolvency petition, you have to wait approximately 3 or 6 months, and you don't have automatic stay. You have to wait the admission for the protection of automatic stay. So if you have to wait so long, it's very dangerous for the company, for the employees, for everything. And we have here the second issue. The number of insolvency are not so bad, thank God, but the core problems remain because they don't have enough resources and the political influence. About the new SME enterprises, I had a presentation. Okay, who cares? We have 5 different proceedings. We have, if I am entrepreneur, or I have, I am a small sole proprietor, I have 5 different doors to go through for insolvency. One of them is the out-of-court agreements, and we don't have, that is also a problem with the principles of the World Bank, we don't have regulation about workout, informal workout. We have to work with civil law from the end of 19th century and our commerce law of 1971. So we need these rules and, for example, code of conduct that the principal recommend with the financial system, but we don't have that. So we have the other 4 doors, 4 proceedings that even Susana say that anyone can file this petition. I not agree. I don't agree with Susana, because it's so complex, the documents. And I want to tell you something. If you can right now, since 1st June of this year, you can only file this request for admission to the insolvency proceeding. You can file only online. But if you have problems, you can go to the superintendency, one of the 7 offices. Yes, but like this information is from the Ministry of Communications and Technologies, and he said, in Colombia, we have only 15 internet spots for every 100 people. Bogota is the capital, and we have 26 spots or set in the place, 26 out of 100 people. And we have only 7 superintendencies office. Okay, because of that, the barriers are technological and geographic. You can file an insolvency without an advisor. And if you are a small company, you have to choose between buy supplies or hiring an advisor and a lawyer. Of course, you can file like a person the petition, but you need someone to explain you what do you need to file, because one of the things that the UNCITRAL says in the recommendation is that the proceedings need to be flexible, need to be conscious that these people, this small business or micro business, maybe doesn't have or don't have, for example, accounting or statements, financial statements. So if you don't have, or if you don't give them a way to file, a way to access a proceeding, they finally close the business, turn off the light, because it's very, very complex. So about the proceedings, I have to say, yes, it's better than we had before pandemic, but I think it's too judicial when what is needed is less judicial. I think that we have experience with some mechanisms less judicial that the law 550 that helped the government to face the crisis of the final 20th century. The steps, you look the presentation of Susana, so many steps, and it's very similar to the reorganization or ordinary reorganization, or the liquidation process, the ordinary, but in less time. You compress the steps in a small time or little time or a smaller time or reduced time. So that doesn't mean that is better. Yes. The regulation is temporary. It's not yet amendment or for more time. The big number here, as Susana said, yes, we have a lot of small proceedings. Why? Because if you see or read the statistics before COVID-19, the majority of the proceedings in the superintendency was for small companies. But right now, these small companies had only the possibility to go to insolvency through these new proceedings. So if you have only a door, you can only go through this door. That is the problem. That is not a consequence that the company or the enterprise choose the new proceeding. The problem is that they have only this door, or reorganize, abbreviated, or simplified liquidation. Finally, I will end shortly, Fabio. In the reorganization, we have a insolvency administrator that is a promoter, and the cost minimum of an administrator is $80,000. That is a huge amount of money for a small or micro company. Yes, our salary, our minimum salary is like $200. So if you have to pay to a promoter $8,000, I think is not easy. The time frame to reach an agreement is too short. You have only 3 months to set the passive, okay? To agree with the creditors, what is the passive, what is the credit, what is the amount, what is the conditions. And only in the same time, you have to reach the agreement with these creditors. And you don't have any steps in these 3 months. And finally, we have a problem because nobody in the proceeding has the authority to decide about the viability of the company. We have now this problem with some big companies. So if nobody in the proceeding have the authority to say you are not viable and you have to go to liquidation, but that is a problem. And in the liquidation, we have some problems in the application of rules for liability discharge. That was a reform in 2012 in the General Proceeding Code. And in this proceeding, first time in the life of Colombia, was said this possibility of discharge for, obviously, persons. My conclusion is, I think that our legislator, with the important support of the superintendency, put our system in a better level. But sometimes with the idea of modern design our system, they have brought some institutions or rethink institutions for the big or small or medium company, but not with the idea of the small and micro company. We have to reach some proceedings, or maybe not a proceedings, some way less judicial, more flexible, less expensive for these kinds of company. I think that was a good effort, but not enough for micro and small companies. Thank you.
Thanks, Diana. Seems to be that the challenges are not quite few, no, not even easy to list all of them, and it seems that different attempts, but with the same problems, right, on the table at the end of the day. Hugo, please, your comments. We are almost running late, but we will have more time, a little bit more time. I'll give more time for the discussions. Go ahead, Hugo. Thanks.
Okay, thank you, Fabio. First of all, I want to thank the AAA and the World Bank Group for having me today, and I'm very honored to be part of this great panel. I have a very brief presentation that I'm going to share. I don't know if the presentation, yes? Okay. Well, we can see in this slide, if we see the chart above on your left side, that the number of liquidation of small enterprises has increased during since the current law came into force in 2014. An average of increase of 30%, and the last 2 or 3 years, 10% or 20%. And if we see the year 2020, we can see that in comparison with 2019, there is no a big gap, there is no a big increase, as many experts, insolvency experts and authorities predicted. And if we see in the chart below this, the years 2020 and 2021, we have a slight increase in the number of liquidations of MSEs, and it's still not a problem, not a wave of liquidations. And on the other side, on the right side, we can see the number of reorganizations of small and micro companies, and where is the same in the whole system of reorganization, that our current law expected to have more reorganizations than liquidations, but in fact it was the opposite, because you know that in Chile the discharge is total in comparison with other jurisdictions where many credits are not allowed to be discharged in different situations. So many companies prefer liquidation instead of reorganization proceedings. And on the other hand, you have that financial education of small companies, MSCs, is very, very low, and they don't have the money to hire some advisors, financial advisors, and they don't have the signals, the red flags to know when they are in a very deep insolvency state, or even if they are starting with an insolvency state, to file for a reorganization proceeding. So the reality is in Chile is that most of the reorganizations are from large and medium-sized companies. And well, we can see in the chart that there is no trend, a real trend of increase in both years 2020 and 2021. The thing is that, as Ricardo Reveco said, that our current law was thought as a mold for large and medium-sized companies. There wasn't adapted for the needs of small and micro companies. And we can see in this chart on the left side, that 55% of the liquidations are for MSCs. Because of the conditions that I mentioned recently. And on the other hand, you have the reorganizations, that large and medium companies cover just the 82% of the proceedings. So we have studied what has happened during this almost 7 years of the current law that was, as Ricardo said, a very big change in comparison with the old bankruptcy law. That the new law allowed more individuals and companies to file for an insolvency proceedings. We can see in the current law that we have an average of almost 2 years of liquidation proceedings length or duration for MSCs. And it's even longer for MSCs than for large and medium-sized companies. So the spirit of the law, of the current law, was to have a 1 year average duration liquidation proceeding. So, and on the other hand, you have the situation that I mentioned, that reorganization has been filed mainly by large and medium-sized companies. So the cost of the proceedings, the fees of the observers who administer these proceedings are very expensive, very prohibited for for small and micro companies. So at the very beginning of the pandemic, at the end of March of last year, I thought, well, what we can do to solve this problem, and I had the opportunity to present to the Minister of Economy a proposal of an amendment of our law, because it was a very good opportunity, this pandemic, to create new insolvency proceedings for MSCs, especially simplified insolvency proceedings, to have a duration of less of 2 years on average, and with a cost, especially of reorganization, very low in comparison with the current reorganization costs. So in September 2020, we entered an amendment of our law to the Congress, specifically to the Deputy Chamber. It passed 100%, and this year it passed the second stage at the Senate, and we are waiting for the Financial Commission to approve the budget of this law amendment. And well, here we can see some benefits and some changes of the simplified reorganization for MSCs. The main idea was to implement a new simplified organization process that aims to reduce administration's cost for MSCs. As Ricardo said, there is a higher cost for MSCs. We're going to eliminate the debt certificate by an external auditor registered at the Financial Market Commission. That is very expensive. We are creating and establishing new categories to differentiate the observers that administer simplified insolvency from those that administer ordinary insolvency proceedings for large and medium-sized companies. So we're going to create a new market of observers that is going to diminish, we think, the cost of their fees in comparison with the current cost of the observers nowadays. The second idea is to increase credit recovery rates for creditors, promoting debt restructuring and business rehabilitation rather than liquidation. And as a superintendent and superintendency, we are going to, we have a very deep, a very important financial, program to increase the financial education of MSCs. We're going to, we have a financial website, a financial education website with some tools. For instance, we have a financial insolvency calculator for MSCs to monitor their insolvency state. And in this case, we have studied that the recovery rates in reorganization is about an average of 70% in comparison with the recovery rate of liquidation that it has an average of 50%, 20%. Another benefit is that the observer will advise the debtor in the elaboration of our reorganization proposal. You know that I mentioned that those MSCs have a lack of financial education, so it will be very good to have the observer advised these debtors in the elaboration of the reorganization proposal. And on the other hand, the superintendency will provide models of reorganization proposal based on our experience in the current reorganization proceedings for MSCs. Other benefits is that initial insolvency financial protection period will have a longer duration, 10 more days to have a better reorganization proposal. Well, I mentioned that we are going to have a lower initial cost for simplified organization procedures, those new categories of observers, the A for senior and for large and medium-sized companies reorganization, and the category B for those simplified insolvency proceedings that we are proposing in our law amendment. And finally, as a benefit of this simplified organization for MSCs is to allowing for telematic audiences for voting the reorganization proposal. And I can mention two more benefits, like the extension of the financial protection period doesn't need the creditor's approval, because you have the, you know that this there is a lack of interest of creditors to participate in those simplified insolvency proceedings, because the benefits of participates in these proceedings compared with the cost of an attorney that represents creditors, it's not a real benefit for those creditors. Well, the last slide is the benefits of a simplified liquidation for MSEs. I have to mention that we based based of these simplified models is the World Bank MSE principles and the UNCITRAL insolvency regime for MSEs. So we studied both World Bank principles and the UNCITRAL insolvency regime model, and we took many parts of these mechanisms, and we included those in our law amendment. And in the case of liquidation for MSE, the simplified liquidation for MSEs, we're going to implement a new simplified liquidation where no constitutive, ordinary, or extraordinary meetings of creditors will be held, except if there is a quorum of creditors that represents 25% of the total debt. So we're going to decrease or diminish the duration, the length of the liquidation proceeding for MSEs. I told you that it took an average of 2 years to almost 8 months, 7 months. The other thing is that we're introducing, as Ricardo said, that there is a lack in our law, a real of the misuse of insolvency proceedings. The idea is the discouragement of the misuse of the bankruptcy proceeding. In this case, creditors could, and the liquidator has the duty to ask the court to determine the misuse of the liquidation by the debtor, concealing assets or financial statements that are not for real. They are intervened to show less assets than they have in reality. And a third benefit is the reduction of fees for a compulsory liquidation, 50% of the cost, about $7,700. Another benefit is the creation, the same as we created in the reorganization insolvency proceeding, the creation of 2 different categories of liquidators, promoting specialization and improvement in the liquidation administration. The idea is to have liquidators specialized in those simplified insolvency liquidations to have, liquidations of MSEs more quickly and without the cost that they have nowadays. Another benefit is the possibility to carry on telematic hearings, to have the asset seizure by telematic means, and the auction proceedings to have by telematic means too. That is the final benefit, that the presential seizure is going to be replaced by telematic procedure, and the auction process could be held on internet sales platforms. So you can see that our law amendment, it has 160 articles, among new ones, among some that were corrected, and it's a very deep amendment of our law. So we are waiting to have this law approved in a few months, I think in 1 or 2 months. So this was my presentation, and I'm open to some questions. Thank you for the time.
Thanks, Hugo. Very interesting. Hopefully it will pass soon, right? You mentioned that it is already advanced, right, in terms of approval from Senate, right?
Yes,
when do you expect? When do you expect, or is there any expectation on timing for the new amendment?
Yeah, we finished 1 month ago the second stage at the Economic Commission at Senate, and we're waiting for the hearing at the Financial Commission at Senate. And after that, there is the third stage, because some of the indications at the deputy chamber were changed at Senate. So I have to present those new indications. I've been during the whole discussion, and I think that the law is going to be approved, I hope, at the end of the year, and probably is going to be on effect March next year.
Okay, great. Yeah, hopefully it will be enacted as soon as possible, and try to introduce the concepts, right? Let's well, I do not have questions from the audience, at least on our Q&A chat here, but I would hear for a few words from Andres, because I believe from the perspective of the World Bank and the, let's say, developments the countries are doing, and what do you think about those developments, and how we may consider the principles, etc., develop everything from now on, right?
Thanks, Fabio. No, I mean, I think it was really fascinating discussion. I think it's both countries have definitely made tremendous progress with the legal reforms that took place relatively recently, because even though Chile is discussing a reform now, we have not to forget that the current law is pretty recent when compared to other laws, no? And the fact that the number of cases has increased so much comparing the current law with the previous one, and the usage of the law and the expertise in the system are all pluses that we have not to forget, no? And the same with Colombia. If you compare the law of 550 back in the day in 1999 during the crisis with the 1116 from, I think, 2006 or 7, again, Colombia has done tremendous progress, and all these emergency decrees, I think, will need to be somehow embedded in the system. One thing that I want to comment on, and it's just one, and I see the two countries with one commonality, and it's a commonality that unfortunately happens throughout Latin America, is the issue of deep financing. Brilliant that now it appears in both laws, right? Now, if I ask, and I heard Ricardo, and I heard everyone in this panel, the reality is how many deep transactions are happening, no? And the reality is very limited. So I think one of the lessons learned for everyone is deep financing is great to have it in the law. It's necessary to enable deep financing, but it just doesn't come out of the blue, right? And this, Fabio, is very important for you, as Brazil has very recently reformed aspects related to deep financing. But if you don't have some sort of stars aligned in which you create the market, you create incentives, you align, as Ricardo was saying, the regulation of the financial system with the insolvency law, and you basically encourage all the parties, even from an educational perspective, explaining that without priority for the guys that put the money now, there is not going to be anything. I mean, there's not going to be a restructuring. There will be a liquidation, and good luck with that, because the values of liquidation, everybody knows that are much smaller, no? So I think lesson learned, putting it in the law is very important, but it's not sufficient. And I think it's a work that all of us have to do to try to make it happen. So that's my take, one of my takeaways, but the one that I wanted to share at this point. Thanks.
Yeah, thank you. Good summary and good conclusions, Andres, because my feeling is as well. I'm very enthusiastic. I'm always was enthusiastic on trying to develop deep financing market in Brazil and try to improve the system, at least in a practical point of view, to incentivize and give more predictability. I believe one of one of the things that through Latin America we need to be very worried is the predictability of not only the regulation but also predictability on the appliance of the law and the rules under the law, etc. So I believe we have it in common as well. Well, thanks all our stars and our panelists. It was a very, very interesting, at least for me, completely wonderful explanation on the systems and on the attempts and on the reforms that are coming and the reforms in place and the experiences. And thank you all. Thanks for participating and having your time to develop our discussion and our debate in Latin America. That's the intention of the Triple Y. That's the joint job with the World Bank. I believe we reached at least the most important topics today, and hopefully we'll be still discussing and debating and developing the systems through Latin America, right? And hopefully as well, after the pandemic gone, and hopefully soon it will be gone, next year we may have also a meeting. I was exchanging messages with Ricardo. I'm already planning our group, me and Javier, our committee here, our Triple Y Latin America committee, is making all efforts for us to have an event and encounter here in Latin America, most probably in São Paulo next year. So pay attention on our communications, and I invite you all to come to São Paulo when we may arrange the dates in a nice trip for all of us. So thank you very much. Stay safe and goodbye. Thank you.
Bye, everyone.
Thank you
Bye
very
bye.
much.
Thanks.
Bye.
Bye. Bye, everyone.
Bye. Thank you.
Bye-bye. Thank you.
Rafael,
Opa,
tudo bem?
tudo certo.
Deu certo, né?
Certinho.
Teve esse probleminha aí da conexão que eu já vi aqui na troca de e-mails pro pessoal. O pessoal lá depois vai. Quem que tá cuidando disso, hein? Será? Você sabe?
Do
Não,
que?
né?
Da troca
A
de e-mails?
conexão desses dois que entraram
Ah,
depois, que você teve que resgatar.
dou uma checada aqui.
Dá uma olhadinha e depois responde lá, porque eu já vi que o pessoal já trocou e-mails para vocês que vão estar responsáveis para a semana que vem, porque a gente tem
Semana que vem.
um próximo evento semana que vem,
Uhum.
porque parece que já aconteceu semana passada de alguém não ter conseguido linkar, entrar ou ser aceito no link, entendeu? Que foi enviado, acho que foi o Javier, que inclusive foi o moderador. Eu vi nos e-mails aqui que o pessoal trocou.
Uhum.
E aí hoje a gente teve dois, né, que não entraram no horário, mas eles falaram aqui que estavam 10, 15 minutos esperando serem aceitos. Então, só porque o pessoal deve já pedir semana que vem, quer dizer, deve vir alguma solicitação aí para vocês. Então, se vocês é que vão cuidar, para que dê uma olhada para isso não acontecer semana que vem também, tá?
Tô anotando aqui
E eu,
agora.
Isso, por favor. E já dá um feedback lá para a turma, sabe? Antes até deles cobrarem. Fala que eu comentei com você, ou pede para alguém aí quem tem contato lá com a Sherry. Eu não sei com quem vocês estão falando lá diretamente, mas é a Sherry ou a Enica, que é o pessoal do Triple Y, né? Do International Insolvency Institute, que eles estão eles já trocaram e-mails aqui, já sugeriram, o Andrés, inclusive, que foi esse primeiro que falou agora e falou no final de novo, ele já falou lembrou que semana que vem vai ter o próximo. E a outra coisa, a gente sabe quantos ficaram aí, quantos viram? Você tem esse controle aí, não? Você deu uma olhada?
O número de participantes que tinha aqui eram 11. Mas se eu não me engano, tinha alguém repetido. Não tenho certeza.
Vendo, assistindo pelo Zoom.
Assistindo. Isso.
E essa turma ficou o tempo inteiro ou não?
O tempo inteiro.
Que bom. Legal. Porque às vezes cai, às vezes tem no começo, depois o pessoal sai, né? Então, eu não vi aqui, né? E a gente não teve pergunta, né?
Não teve nenhuma pergunta no Q&A.
E o pessoal entrou e saiu? Você sabe que se isso foi desde o começo? Ou esse número foi o número final? Só?
Pelo que eu olhei, foi isso a reunião inteira.
Desde o começo, tá bom.
Desde o começo até agora, no finalzinho, não tinha gente ainda.
Então tá bom. E a tradução foi tudo bem também?
Tudo certo também. Inclusive,
Tá.
deixa eu até parar de gravar aqui.
Depois corta essa parte final aí para pôr na internet.